One of my favorite Saturday Night Live comedy sketches is Black Jeopardy, specifically the one featuring Tom Hanks as a contestant. He walks out wearing a bright red hat and speaks with a relaxed Southern drawl. At first, it seems like an obvious setup. He's clearly the outsider as a white man on this fictional game show about Black culture. But then the game starts, and Tom Hanks' character keeps responding correctly. I find this particular sketch to be brilliant because of how it depicts societal division and then upends the common narrative. The audience isn't laughing about the differences on display. They're laughing because all the contestants, regardless of how they look, feel the same way. About authority, about being taken advantage of, about fairness, about how systems can fail people. The prompts on this fictional game show are intentionally vague and serve to highlight how culture, instinct, identity, and experience pull us in opposite directions. But if we strip things down to the heart of the matter, we can find consensus. So in the interest of challenging assumptions and discovering common ground, I'm going to pose a Jeopardy-style prompt. Federal laws imposing stiff penalties for use or possession of this good were shaped in part by racial discrimination. If you answered, "What are drugs?" you'd be correct. And if you answered, "What are guns?" you'd also be correct. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we're discussing the evolution and consequences of American drug prohibition and gun control. If you like what you hear in today's episode, visit go.osu.edu/drugsonthedocket to follow the series. Starting off with a bang, terrible but appropriate pun considering today's topic, but I feel no remorse saying it. I really hope that this episode is going to challenge our listeners' underlying assumptions that they probably have about gun access and firearm restrictions and enable them to connect the dots a bit where other prohibitionist policies are concerned. But without further ado, Doug, will you do the honor of introducing our guest?
Absolutely, Hannah. It's my pleasure. Today, we're very fortunate to be joined by Jacob Sullum, a nationally syndicated columnist, author, and senior editor at Reason magazine. He spent more than 3 decades covering issues like drug policy, public health, gun control, and criminal justice. He's recognized, rightly so, as one of the most influential voices challenging conventional narratives about all these policies and particularly their impact on civil liberties. Jacob's work has been featured in major news publications ranging from the Wall Street Journal to USA Today, New York Times, National Review. He's also appeared on all the networks, Fox News, CNN, NPR, bringing thoughtful analysis on personal freedom and public policy to a wide audience. And we're, again, grateful to have you here, Jacob, to share all this insight and background and particularly your latest book with our audience. So thank you.
Thank you. Thanks for having me.
So like Doug said, you've covered gun control and drug policy pretty extensively in your career writing. And in your latest book, you go into detail about a lot of, I consider it really rich history behind laws that restricted access to guns, as well as laws that criminalize drug use and possession. So before we dive into any specific more modern day issues, what would you share with someone who's generally opposed to gun control but supportive of drug prohibition?
Well, I think that the striking thing, if you look at the history of these laws, is that bigotry played a really big role in the evolution of both kinds of laws. I think people who are critics of the war on drugs are probably familiar with some of that history, the way that the early drug laws in the U.S. were driven by animus against various outgroups. But the history of gun control makes it even clearer. There's some dispute about the extent to which racial prejudice contributed to the drug laws. They clearly played an important role in my view. But when it comes to gun control, it's very clear. It was explicit from the earliest gun regulations that this was about disarming Black people. In some cases, the laws actually restricted the rights of free Black people more because they were an example of freedom that might inspire rebellions and they might assist rebellions. Those laws evolved after the Civil War, so that initially they were very explicitly aimed at people based on race. After the Civil War and the 14th Amendment, you weren't supposed to do that anymore. So what you have is laws that are neutral on their face, but enforced in an obviously discriminatory way. And so the goal was to keep Black people disarmed, defenseless against white supremacist violence. And that goes through Reconstruction, through the Jim Crow era, through the Civil Rights Movement. You still have these laws on the books that give local authorities a great deal of discretion in deciding who is allowed to own a gun, who is allowed to carry a gun. This is part of a social control strategy. Conservatives who support gun rights are familiar with that history, and they will often bring it up. People who are critics of the war on drugs tend to lean more to the left, and they're likely to support gun control and probably are not as familiar with the history of the gun laws.
You mentioned briefly, and I think it's worth really leaning into in the history, which is the role that discretion played in the enforcement of these laws. I think it's something we still see in the data today, that these laws were always too broad to be universally enforced, and that enforcement patterns always reflected, in-group versus out-group dynamics. We'll get to Hemani and some of the federal gun restrictions by the end of the hour. But my sense is if we had full enforcement of these laws, a lot more people with political power would be troubled by just how broad they can be. So I wonder if you talk about sort of both the history of enforcement and then maybe get us to today about whether and how that's the right way to frame some of the fundamental concerns with these laws today.
Initially, you have a very explicit animus against certain groups. Then later you have laws neutral in their face that are enforced in a racially disproportionate way, at least, and oftentimes in a deliberately discriminatory way. And as you mentioned, if you have a law that millions and millions of people are violating every year, there's no way that you're going to arrest and prosecute even a substantial percentage of them. It's going to be a tiny percentage always. Who are those people who happen to come to the government's attention, who happen to get caught, arrested, searched, prosecuted, sent to prison? How long do they go to prison? All these questions, right? And at every stage of that process, you see racially disproportionate impact. And you can argue about why that is. Some of it may just have to do with, for example, if you look at marijuana, the way marijuana possession laws were enforced, if Black people have less opportunity to consume marijuana in a private setting where they're unlikely to be harassed by police, they're less likely to be arrested, right? If police focus their resources on high crime neighborhoods that happen to be disproportionately Black, you're going to see more Black people get arrested. If Black people on average are less able to afford legal representation, they're more likely to be convicted, more likely to go to jail and go to jail for longer periods of time. When you have laws like these that give law enforcement agencies very wide discretion, inevitably some people enforcing the law will be actual bigots, right? Or they will have maybe biases they're not so much aware of. And you will see that in the results of who they search and who they prosecute and all that stuff. The point is that the law gives people who are enforcing the laws such wide discretion that any racial bias that actually does exist will have sort of free rein. There was this law in San Francisco that required licenses for laundries specifically in wooden buildings as opposed to brick buildings. Of course, this was a Chinese-dominated industry in San Francisco. And it also so happened that no Chinese laundry owner was ever able to get one of these licenses, right? Just so happened. Now, that went to the California Supreme Court, and they said, this is fine. This is like a public safety measure. It's a reasonable regulation. It's cool. Went to the Supreme Court, and they said, no, because this is very clearly discriminatory. It's a violation of equal protection, given the Chinese business people never were able to get these licenses. And so that's similar to what you saw with gun licenses, that you just so happened, you had this neutral law, and it just so happened Black people could never get these licenses, right? That's kind of striking.
I think there's so much richness here and so important to know this history in both arenas, but I think it's especially interesting, at least my perception is that, at least on the left, these racial disparity, equal justice concerns have been really foundational to shifting policy debates and ultimately laws in the marijuana space and maybe in drug policy more generally, that there's a kind of a keen understanding that these broad prohibitions have been applied in disparate ways, and that's a harm that the law ought to be addressing. And I think the patterns are pretty similar when it comes to prosecutions and punishments in the gun space, that those are also disproportionately African Americans and racial minorities who are getting the brunt of these laws, and particularly the most severe sets of sentences. Do you have a sense, again, you're the one sort of comparing these two fields, is it just pure politics that's making it harder for people to understand that the concerns they have in the drug war setting, also are very real in the gun war setting, or do you think something else is in play?
No, I think it's the pre-existing policy positions. People who tend to favor gun control are not inclined to look very closely at its history and how it works in practice today. But if you look at something like stop and frisk programs in New York City, for example, what was that about? Well, ostensibly, it was about taking guns away from people. Did they do that very often? No, they almost never did that because they almost never actually found guns, even when cops would pat somebody down because they thought he might be armed, supposedly. Almost never found guns or any other kinds of weapons. But what did happen in practice was that the cops systematically harassed young Black and Hispanic men in New York City, stopped them, questioned them, often frisked them, rarely found anything, rarely arrested them. But they would often say, if you have anything on you that I need to know about, you should probably just show me. And so they'd pull out a little bag of marijuana or a joint or whatever. And at the time in New York State, supposedly low-level possession of marijuana would have been decriminalized. But if it was in public view, it was an arrestable offense, became a misdemeanor. So what was ostensibly an anti-gun, anti-violence program ended up catching all of these marijuana consumers on these penny ante charges, but still they're burdensome. They can disrupt your work. They cost money. It's embarrassing, obviously, but all that, all the costs that are associated with being arrested and prosecuted, being disproportionately imposed on these people. Now, if you asked Bloomberg, the mayor at the time, or police officials, what was this about? I said, we're trying to protect these communities. We're trying to reduce gun violence in these communities. And Bloomberg, unfortunately for him, the way he phrased it was, it's not about actually finding guns. It's about deterring people from carrying guns. Now, if you're familiar with the Supreme Court precedents in this area, you know that that is not a valid justification, deterrence, that we're just going to randomly stop young Black and Hispanic men and they'll get the message and they'll stop carrying guns. That's not cool under the Fourth Amendment. He probably didn't realize that at the time, but in the end, a federal judge found that the program was dubious both under the Fourth Amendment and under the 14th Amendment, given its disproportionate racial impact. But, the ostensible motivation was benign. It was we were trying to help people in these communities, but the progressives didn't necessarily pay attention to the fact that this was ostensibly all about gun control, or question, well, why is it illegal to carry a gun in New York City for almost everyone at the time, right? That goes to how much discretion the government has in deciding who is allowed to do that. And of course, the Supreme Court has been very skeptical of that in recent years.
You nicely highlight the way these things work in synergy, right? That if you have a world in which a lot of people have guns and a lot of people have drugs, and yet we have broad laws that are under enforced around them, you can sweep up a bunch of folks and find either and then justify your sweep on that basis. Again, I think stop and frisk lessons are profoundly interesting.
Can an effective regulatory framework without enforcement work? Or do you still need enforcement if you have a regulatory framework, if you've legalized drugs? And in the underlying assumption here is that you need a regulatory framework for people to access those drugs safely.
Yeah, well, I'm a crazy libertarian, so I'm generally against almost all the regulations and the taxes, special, taxes that states tend to impose when they legalize marijuana. I realize most people don't agree with me on that, but they should recognize that there is a trade-off between taxes and regulations that you think are reasonable or necessary, and actually achieving a transition to a legal market. California had a terrible problem with this because their taxes were too high, their regulations were too onerous, and you had a pre-existing black market that supplied marijuana. And even today, and this is nearly a decade after they legalized recreational marijuana, by the state's own estimate, maybe 40% of the market represents sales by licensed businesses. That's a problem, right? In New York State, it's even lower, maybe a quarter. So you're talking about maybe 3/4 of the marijuana market in New York is still unauthorized dealers. And then in a situation like that, you will absolutely get demands from the people who went through the trouble of jumping through the hoops and getting the licenses and paying all the costs that entails, and who have to pay taxes and all that. They will want the state to crack down on unlicensed dealers and arrest them. And then, yes, you will see similar patterns as you saw under Prohibition. The penalties may not be as severe, but you will see similar disproportionate impacts. And I would say that the best way to avoid that is to make the legal market as easy to access as possible, that you should keep the barriers as low as possible. In other words, if people want to sell marijuana, you should make it as easy as possible for them to do that. And I think states are starting to realize that. So in California, they're reconsidering taxes, they're reconsidering some of the regulations. Every time you think there's a regulation that makes sense, think about what impact is this going to have in terms of placing the black market with a legal market. Politicians tend not to give that very much thought.
The enduring problem we're seeing in both arenas is there's a group of folks who trust government as long as it's not necessarily punitive government, right? So that, the folks on the left may not like drug prohibition, may advocate for legalization or some kind of reforms to get away from criminalization. But then once they turn to a legal market, they're like, of course, government should have lots of fancy rules and restrictions and determine the terms of the market, just like we want them to do in the gun space as well, right? We're all for gun regulation. We're not saying completely prohibit. The Supreme Court precludes that now as a matter of constitutional doctrine under the Second Amendment, but we're not inconsistent at all. We're actually pro-regulation. We just want to hyper-regulate for safety and other goals, both of these marketplaces. Do you hear that in pushbacks to your book and in your own sense of maybe there is some consistency, at least in that respect?
The regulatory approach, from my point of view, it's valid in certain respects, right? So if you have a legal market in drugs, I think it's valid to say you have to be a certain age to buy these drugs, for example. I think it's valid to say you shouldn't be driving when you're intoxicated, regardless of what the drug is, right? Whether it's alcohol or some other drug that might affect your ability to drive. These are reasonable rules, but once you get beyond that area, especially when you get the detailed requirements that they had in many states initially, even if you're not opposed to them in principle, you have to think about what are the trade-offs. And yeah, you do need enforcement, and it may not be as severe as you see during Prohibition, but there are costs to all of that.
I hear politicians, or at least politicians on the left, saying we're for common sense gun control. Is common sense gun control common sense to you, or do you find that it's still an infringement on a civil liberty in terms of like being able to conceal and carry or just possess a firearm?
Yeah, I mean, it depends what they mean by common sense gun control, but most of the policies that people describe as commonsensical, there's very little evidence to show that they do work. So when you're talking about things like, let's ban certain kinds of rifles that have certain features that are not really essential features, but some gun owners find them useful. So, for example, a folding stock. In some states, exactly the same gun, if it has a folding stock, is an assault weapon, therefore prohibited. And if it doesn't, it's okay. You wouldn't expect restrictions like that to have any impact on violent crime in general or mass shootings in particular. And there's very little evidence they do, but it's considered to be common sense. Other policies that politicians often recommend include so-called universal background checks. And what that means is that if you're transferring a gun, even if you're not a federally licensed dealer, you still have to conduct a background check, which in practice means you have to go through a licensed dealer, right? So it adds another inconvenience and expense to that transaction. And the data suggests is that most gun owners who want to sell one of their guns, they don't comply with that. Not necessarily because they're scofflaws. Maybe they don't even know the law exists, but if they do know, they're like, why should I have to jump through these hoops to dispose of my own property? So there's not very good compliance, but the underlying problem is that what background checks accomplish is not really very useful in terms of protecting public safety, because if they're working as intended, they're going to block gun sales to people who are prohibited from owning guns. And there are vast categories of people who are prohibited from owning guns under federal law, including many millions of people who pose no plausible threat to public safety. So you're casting a very wide net in an attempt to catch, people you think are going to use these guns to commit violent crimes. Meanwhile, the people who actually do want to commit violent crimes with guns have lots of ways around those restrictions. And they, if you look at surveys of criminals, of course, these are criminals who got caught. So you may say it's a biased sample, but they're, people in prison, you use guns, where do you get the guns? Well, they typically do not get them over the counter from a gun dealer. They typically get it from various informal sources that are never going to be affected by any law that you might pass. Right. So in practice, policies like these don't really work, and there's not reason to expect that they would. So that's one point. Then you could say, well, we need something more ambitious. The problem with that is that you already have maybe 500 million guns in circulation in the United States. Then you have the political reality that a lot of people, support the Second Amendment and believe people should have a right to own guns. And so politically, it's difficult to get really ambitious gun controls passed. And then legally, it's essentially impossible. Given the jurisprudence on this, whether you agree with it or not, that's a reality, right? So things like mass confiscation of guns, or even mandatory registration of guns, handgun bans, we know the Supreme Court has already said that that's not constitutional. And ultimately, bans on certain arbitrarily selected rifles, they're also going to be overturned. And like I said, that's not even a very ambitious measure, really, because it doesn't make any sense. So you have to deal with those realities. And so given those realities, it's not reasonable to expect you to accomplish much in terms of reducing gun violence through gun control. So what you have to ask is, what are we really concerned about? Well, we're concerned about violent crime. We're concerned about suicides. I mean, that's actually the main kind of gun death in America is suicide. The way you address suicide is going to be very different from the way you would address violent crime. And so you have to talk about specifics.
Whether it's restricting gun access or gun ownership or access to drugs. Which of these harms strike you as the most misunderstood by policymakers? Because these are such emotionally charged policy areas, a lot of the narratives tend to focus on the harms, but the harms are misunderstood, or at least the laws are not accomplishing what they set out to accomplish. How do we have more evidence-based conversations so that we're not treating gun control and drug prohibition as like moral issues, so that the policies are actually effective? What is it going to take to shift the public toward these evidence-based conversations?
Yeah, I mean, I guess it's a combination of looking at what do these policies mean in practice? Who are you arresting? Who are you sending to prison? And is it actually accomplishing what you want? Is it likely that it would do that? And obviously, all of those people are suffering the consequences of that policy. Who are they? Are these dangerous criminals that the public is being protected from? If you arrest somebody because he's a marijuana consumer who owns a gun during a traffic stop, one of the cases in the Fifth Circuit, guy had remains of a few joints in an ashtray, and he had, I think, 2 guns, and that was enough to make him guilty of a federal felony, and he got a 4-year prison sentence. Are we safer because of that? One of the cases I talked about a lot in the book is Walden Angelos, who got a 55-year mandatory minimum for a few relatively small marijuana deals. Why? Because he happened to be a gun owner. That seems insane on the face of it. And in that particular case, people from across the political spectrum said that's insane on the face of it, right? And Congress actually did modify that law somewhat, so you can't stack charges in a single case anymore. What Congress said is, okay, you can't do that anymore. It's got to be a prior conviction from a separate case. So that's an improvement, but maybe don't send people to prison for years simply because they sell marijuana, which is a legal business in most states now, and also happen to own guns, which is a right protected by the Second Amendment. So I think you can talk about what these laws mean in practice and whether the really onerous costs you're imposing on a certain number of Americans every year are worth it.
We've been teasing the Supreme Court. I'm going to focus us on it to make sure we have time to cover it fairly thoroughly, because one of the things that I talk about in my marijuana seminar is the interesting reality that over the last 20 years or so, when we've seen incredible state policy innovation in the marijuana reform space, we haven't seen any Supreme Court work particularly related to marijuana, but we've actually seen, other than some of the criminal cases that come up through the federal drug onerous punishments and others, drugs have sort of been off their docket in terms of some of these civil liberties issues. And as you know, there's long been a concern that drug cases kind of allow for a civil liberties free zone, whether it's the Fourth Amendment or other constitutional protections. Doctrine has evolved in a way that if you're chasing after drug dealers, it seems like police get the benefit of the doubt in a lot of those kinds of cases. There are a couple of cases after California first legalized medical marijuana that made its way to the Supreme Court, but they've been somewhat studiously avoiding taking up these issues. And then around the same time, about a little less than 20 years ago, we got the Heller case from the Supreme Court, where the court finally, after avoiding this issue for an awfully long time, said the Second Amendment provides an individual right to keep and bear arms, not just a collective right. And since then, we've had a series of cases really ramping up in the last 4 or 5 years, sort of testing what that means, especially for this term, federal gun control law, as it reflects in the existing prohibition on any unlawful user of a controlled substance ever possessing a gun. That's what's in front of the court in a case called Hemani. And I guess I wonder, especially since you've literally written the book on these two stories, are you excited that they're coming together in front of the Supreme Court? Are you concerned that what has seemed to have been a mostly but not robustly expanding Second Amendment right from the justices might screech to a halt when they throw drugs into the mix? I'm just interested in your take on what we might expect from the court on that front, or even more generally, your own sense of the role the court might play, not just in ratcheting back gun prohibitions, but also drug prohibition.
Well, I do worry about sort of anti-drug sentiment influencing how the Supreme Court comes down on this. So this is a Texas marijuana user who was charged with illegal gun possession because the FBI, while conducting this supposedly a terrorism investigation that never bore any fruit, never resulted in charges, they searched his house. They found he had a pistol, legally owned pistol. Except that they also found some marijuana, a little bit of cocaine, but the charges against him hinged on the marijuana because he admitted that he smoked maybe a few times a week. And that was it. That's all you need. He was clearly guilty because he was both a marijuana user and he also owned a gun. You don't have to handle guns while you're stoned or anything like that. It's just simply owning a gun and also using marijuana. That case was dismissed based on precedent in the Fifth Circuit that said it's inconsistent with the Second Amendment to charge somebody with a crime simply based on those two facts, that you need more. And so more might be, this guy is stoned all the time and he also waves guns around while he's stoned. Right? It might be something like that, but something more. So most cases would not be prosecutable under that standard. If you go look at the cases that the Justice Department describes in press releases, or you look at the cases that result in litigation, very often what's happening is police stumble on the two facts that you need to convict somebody through a routine traffic stop. There was a case where cops wandering by somebody's apartment, smelled marijuana, went inside, also found a gun. One of the cases in the Fifth Circuit involved a domestic violence report, and police came and they found both a gun and marijuana. Right. So it's not that, oh, this person posed such an egregious threat to public safety that he can't possibly be allowed to own a gun. It was simply because those two facts happened to be discovered. So what's interesting about the case, though, is if you look at the briefs, you will see a very interesting mix of people who are opposed to the Trump administration's position. The Trump administration wants the Supreme Court to reinstate that prosecution, to reject the Fifth Circuit's reasoning on this, and say this law is fine. We don't need to worry about it being consistent with the Second Amendment. But you have major gun rights groups, including the NRA, Gun Owners of America, Firearms Policy Coalition, saying Trump administration is absolutely wrong, and this is clearly inconsistent with the Second Amendment. There's no historical analog that is relevantly similar to this policy. And they're right, by the way, about that. The NRA in particular is interesting because until a few years ago, they did not want to touch this issue. They very carefully avoided commenting on what about people who use medical marijuana that's legal under state law. They lose their Second Amendment rights under federal laws. That doesn't seem cool. NRA did not want to talk about it. A few years ago, I finally got their spokesperson to say this isn't right. And now they've evolved even further, and they're coming in very strong and saying, this is absolutely absurd policy. It's totally inconsistent with the history. So you've got those people, but then you also have normal, and you have the Drug Policy Alliance. You have, the National Association of Criminal Defense Lawyers. You've got the ACLU. They're actually helping to represent Hemani in this case. That's really interesting because the ACU is not a big defender of the Second Amendment. And, historically, they said this doesn't protect an individual right. It protects a collective right or something like that. And there might be ancillary problems having to do with the Fourth Amendment or maybe the 14th Amendment, but it's not a Second Amendment issue. But they signed on to this brief saying it's, among other things, a Second Amendment issue. There's also the issue of whether the law is unconstitutionally vague because who is an unlawful user of a controlled substance?
There's a bunch of fascinating issues in front of the Supreme Court, but the extent to which, if broadly applied, arguably there's 50 million Americans regularly violating this law because my understanding of gun possession data, maybe as many as half or at least a third of U.S. households have a gun within it and people are gun possessors. And of that group, probably 20% are regular marijuana users, whether for medical or recreational purposes. And you put those together and we're talking millions and millions upon people, even though this gets back to our enforcement story, only a few hundred people are prosecuted under this federal law on a regular basis, and whether and how the Solicitor General's office will argue in front of the court, whether the court will be drawn to a more narrowed interpretation, like along the lines you were suggesting that, maybe the only constitutional way to interpret this law is you're actively high while you're possessing the gun, or some historical analog to prohibitions on persons while drunk having their guns in the public square or something along those lines.
The Biden administration favored that analogy. The Trump administration has abandoned it. For good reason, because those laws were narrowly aimed at drunken gun handlers. They said, if you're drunk, you shouldn't be carrying a gun in public. Sometimes they said you shouldn't be firing a gun in public when you're drunk. Also good advice, They did not say, if you are a drinker, you may not own a gun. So the law is only applied in particular contexts in public while you're intoxicated. And the Biden administration said, that's pretty similar to this because we're saying the same thing. And no, you're not, because you're saying anybody who uses marijuana may not possess a gun, period, ever in any context. That's quite different. It would be analogous to saying, drinkers may not own guns at all. So the Trump administration abandoned that analogy, but their new one is not any better because the main one they're using now is, well, historically, habitual drunkards could be restricted in various ways. So right away, we're equating all, marijuana users with habitual drunkards. Who were habitual drunkards? There weren't just people who drank or drank regularly. These are people who who drank in a very problematic way, or at least that's what the authorities determined, such that they weren't able to support themselves or their families, such that they got into trouble a lot, right? So that's not the same as the entire group of cannabis consumers. They have to argue, and they do, that even patients who are using marijuana for symptom relief in compliance with state law somehow pose a public menace, right? And that's their implicit assumption. To justify this categorical prohibition, you have to be willing to say that. And that applies, by the way, to the other categorical prohibitions, like on people with nonviolent felony records also they lose their Second Amendment rights forever. Whereas, if you're a cannabis consumer, you can stop consuming cannabis and you're allowed to own a gun. But once you have that criminal record, you can't ever own a gun legally, right? And so this case is interesting because of the intersection of drug policy and gun policy, but also because it's the first opportunity to really address these categorical prohibitions that are based on the assumption that people in these groups are dangerous, even though when you look at the criteria, that's not really a valid assumption.
And my little prediction for the time being is the Supreme Court's going to be struggling for quite a long time trying to figure out how to balance its jurisprudential and philosophical views about the Second Amendment and guns with all of these broad federal laws. There's obviously a bunch of state laws out there that are also doing gun control in a variety of ways. But in a kind of way to wrap up, do you think that's likely to bleed over? And again, I think the Hemani case is one example. The other cases, Daniels, you mentioned from the Fifth Circuit. Fifth Circuit's not seen as a particularly liberal circuit, and yet we're getting very pro-defendant type rulings in these gun cases, not just vis-a-vis drugs, but on some of these other broad prohibitions you mentioned. In keeping with the theme of your book, should that lead to some of these more conservative justices and judges recognizing that these broad drug prohibitions also should be viewed as constitutionally suspect? We had the honor of having David Posen speak with us last season about his book about kind of different pathways that the Supreme Court could have taken but didn't in order to provide more constitutional protection, at least for drug users, if not necessarily for drug sellers in the marketplace. I'm wondering if you hold any hope that as the judiciary starts to be more questioning of these broad federal prohibitions, especially when they intersect with drugs and guns, whether that might not only lead to a pro-defendant jurisprudence on the gun side, but could inform their views on some of these drug issues? Or is that so much harder because there isn't a textual hook like the Second Amendment and there's a bunch of bad jurisprudence out there?
I don't have much hope for that. I don't think it's going to carry over. But it is interesting, like you mentioned, the Fifth Circuit is probably the most conservative appeals court, and yet they have taken what, at the time was a pretty bold position in saying, generally speaking, really, in practice, most prosecutions under this law are unconstitutional, and applying the Supreme Court test that they laid down in Bruin. It's very difficult to show that this is consistent. This policy is consistent with the history of firearm regulation in the United States. So that's encouraging to me because you have people on the left and the right coming together on this issue for somewhat different reasons, but they both perceive a policy that's unjust and unconstitutional. And the conservatives see that even though it involves drugs, and the progressives see that even though it involves guns. Right. So I think there is some potential on issues like that for left-right alliances. I think, stop and frisk programs present a similar opportunity, right? That goes back to the very strict gun laws that they're enforcing. That's the whole pretext for the operation. So you can see common ground between left and right on that issue too, I think. The thing with marijuana is that it's becoming a legal drug now, right? So to the extent that it becomes more and more like alcohol, it becomes very clear that this makes no sense, right? If you're not going to ban all drinkers from owning guns, why would you ban all cannabis consumers? So there's hope in that area, I think. But when it comes to other drugs, as you've probably discovered, you have to make the argument again and again. People do not apply principles. They don't say, well, what we learned from this is that maybe, no, you got to start over again from scratch.
In an academic institution, you at least hope some lessons will persist, but absolutely it's true that there's a lot of history there that you're fighting up against often in these settings.
Is there a world where the public's attitude could shift, like social acceptance of marijuana when it comes to gun ownership and access? Because where I live and in the world I grew up in, I don't know that I can picture that.
I live in Texas, so it's not hard for me to imagine. In the book, I compare Texas and California. Right? And so in Texas, if you want to own a gun, if you want to carry a gun, You don't need a permit for either of those things. You have to meet the criteria, right? So you have to be a legal gun owner, but otherwise you're good to go. Californians would think that's insane. That attitude is expressed in their laws. They have much stricter gun laws. If you want to use actual cannabis in Texas, that is still a crime. In California, of course, it's not a crime at all, and you can buy it from state licensed stores and so on. So that's obviously, that reflects the predispositions of people who tend to live in those states, right? They have certain attitudes towards drugs and certain attitudes toward guns, and that's reflected in the laws that their legislators pass. What I hope to do is to sort of get beyond those attitudes and get to underlying principles, right? One of which is maybe we shouldn't criminalize conduct that violates no one's rights, or conduct that is possibly harmful, but typically is not harmful.
I really enjoyed, hearing your perspective on these sets of issues. Grateful for your work in your Beyond Control book, and particularly grateful you spent an hour or so helping us understand it. So thank you so much. Really appreciate it.
Thank you.
Thank you, Jacob.
Drugs on the Docket is a production of the Moritz College of Law, Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.